Welcome to the lecture for Assignment 2, Civil Dispute Resolution. As always, when listening to the lectures, please have in front of you your textbook and the appropriate question batch questions, which in this case would be question batch 2. If you remember from the first assignment, civil law is a law dealing with the rights and duties of individuals among themselves. So let's jump right into it. And first of all, we will talk about the federal court structure. So if you can turn in your textbook to page 45, that would be an appropriate place to begin. With each court system, there's a series of layers. And with the federal court system, the lowest court level is referred to as the district courts. So if you can follow with me on page 45 under the heading District Courts, the textbook states that the district courts are general trial courts in the federal court system, and the textbook also states that most federal courts begin in the district court, and it is here that issues of fact are decided. Now also, if you take a look at the second paragraph under the heading District Courts on page 45, the textbook states that Congress has established 94 federal judicial districts, each of which is located entirely in a particular state. All states have at least one district, while certain states contain more than one district. For instance, New York has 4 districts, Illinois has 3, and Wisconsin has 2, while a number of less populated states make up a single district. The key thing in the federal court system is that when a case is first filed, it normally begins in the district courts, which is the lowest level in a federal court system. Next, we have the Court of Appeals. Again, follow with me, page 45. Under the heading Court of Appeals, the textbook states that the Congress has established 12 judicial circuits, 11 numbered circuits plus the D.C. Circuit, each having a court known as a Court of Appeals, which primarily hears appeals from the district courts located within its circuit. Now if you can turn to the next page, which is page 46, and if you look at the top on figure 3.2, you'll see that Pennsylvania is going to be the Court of Appeals for Pennsylvania is going to be in the 3rd district. So it's the 3rd Circuit Court of Appeals, which hears courts of appeals, which hears appeals from cases in the district court level located in Pennsylvania. It's the 3rd Circuit Court of Appeals for Pennsylvania cases. Now, if you can turn back to page 45, second paragraph under the heading Court of Appeals, the textbook states that the function of the appellate courts is to examine the record of a case on appeal and to determine whether the trial court committed prejudicial error substantially affecting the appellate's rights and duties. If so, the appellate court will reverse or modify the judgment of the lower court and, if necessary, remand or send it back to the lower court for further proceeding. If there is no prejudicial error, the appellate court will affirm the decision of the lower court. So to recap, cases in the federal court system usually start in the district courts, and then if there is an appeal, the appeal is made to one of the circuits of the Court of Appeals, which is the intermediate level in the federal court system. Now the highest level, the highest court in the federal court system is going to be the Supreme Court. So again, if you can follow with me on page 45 at the bottom under the heading Supreme Court, the textbook states that the nation's highest tribunal is just another term for court, is the U.S. Supreme Court, which consists of 9 justices. And the Supreme Court's function is to review decisions of the federal courts of appeals, and in some instances, decisions involving federal law resolved by the highest state courts. Please turn to page 46. Take a look at the first sentence. It says, the second way in which the Supreme Court may review a decision of a lower court is by the discretionary writ of certiorari, which requires a lower court to produce the records of a case it has tried. Now, almost all cases reaching the Supreme Court come by means of writs of certiorari. If 4 justices vote to hear the case, the court grants the writ. When there is a federal question of substantial importance or a conflict in decisions of the U.S. Circuit Courts of Appeals, only a small percentage of the petitions to the Supreme Court for review by certiorari are granted. However, because the court uses the writ as a device to choose which cases it wishes to hear. So if you're at the appellate court level and you lose and you want to appeal the decision to the U.S. Supreme Court, you would submit your appeal to the U.S. Supreme Court, and if the U.S. Supreme Court decides to hear the case, it would issue a writ of certiorari, meaning that 4 of the 9 justices have agreed to hear the case. But keep in mind, only a very small percentage of the appeals to the U.S. Supreme Court are actually heard by the U.S. Supreme Court. So to recap this information, if you could go to question batch 2, question 1. The question asks, which of the following statements concerning the U.S. Supreme Court is or are true? The first statement is the Supreme Court is the nation's highest tribunal. That would be a true statement. Second statement says the Supreme Court consists of 9 justices. That's a false statement. The Supreme Court consists of only 9 justices. Now, what's important when you're putting down the answers to the question batch questions, you shouldn't only put down whether it's true or false. If it's false, please write down what would make it true. Because perhaps in your first exam, I might give you a question that says, the Supreme Court consists of 9 justices. You wouldn't know that that would be true. So it's very important, if you have a false statement on the question batch questions, that you write down in your notes what would make it true. Next, the Supreme Court may decide to hear a case by granting a writ of certiorari. That would be a true statement. Finally, a large percentage of petitions to the Supreme Court for review by certiorari are granted. That's a false statement. Only a small percentage of the petitions to the Supreme Court for review by certiorari are granted. Next, let's turn to the state courts. State courts are going to begin on page 46. Now, each state and the District of Columbia has its own independent court system. At the lowest level of the state court system would be inferior trial courts. These are described on page 47. These courts decide the least serious criminal and civil matters, and these courts may be referred to as municipal courts, justice of the peace courts, traffic courts, or small claims courts. Small claims courts are going to be courts that hear civil cases involving a very limited amount of money. The next highest level in the state court system are trial courts. These courts can hear all criminal cases other than minor offenses. There is typically no dollar limitation on their jurisdiction in civil cases. And these courts have a variety of names, including county courts, district courts, superior courts, circuit courts, common pleas courts, and also special trial courts, such as probate courts or family courts. Then finally, we come to the appellate level. And in some states, this may include 2 levels, an intermediate appellate court and the highest appellate court. And in most states, the first appeal is by right, which means that the appellate court has to hear it. So if you take a look at page 47 at the top, that gives you a graphical depiction of the state court system. Again, a lot of cases start at either the inferior trial court level or the trial court level, and then they move up the ladder to the intermediate appellate court. And sometimes the highest appellate court in a state may be referred to as the state Supreme Court. Let's move on to jurisdiction. Jurisdiction begins on page 47. It moves on to page 48 and beyond. But what jurisdiction is, it's the authority of a court to hear and decide a case. Now, in order for a court to hear and decide a case, the court must have two types of jurisdiction. First, it must have subject matter jurisdiction. And this is the authority for a court to decide a particular kind of case. So, for example, in the state court system, there is a court that's referred to as the probate court. Basically, what the probate court does is it'll do things like it'll validate wills. So if somebody dies leaving a will, the will will state to whom the property shall pass upon that person's death. And the probate court will oversee that process. Now, you wouldn't expect, however, the probate court to hear a DWI case. That would be in a different court. That would be in a state criminal court. So in other words, the probate court of a state would not have subject matter jurisdiction to hear a DWI case. It would not have the authority to hear that particular kind of case. So again, in order to hear and decide a case, the court must have two types of jurisdictions. The first is going to be subject matter jurisdiction. The second is going to be jurisdiction over the parties to a lawsuit. Now, a court may obtain jurisdiction over the defendant in a lawsuit if the defendant lives and is present in the court's territory, or if the transaction giving rise to the case has a substantial connection to the court's territory. So let's say you wanted to file a civil action against a automobile driver who you're alleging negligently ran you over. Now, if that defendant, if the individual that you're suing was a resident of Pennsylvania, then the Pennsylvania court should have jurisdiction over the defendant because the defendant lives and is present in the court's territory. Or if, for example, you were run over in Pennsylvania by an Ohio driver, a Pennsylvania court may still have jurisdiction over the defendant because the transaction giving rise to the case had a substantial connection to the court's territory. In other words, even though the defendant was a resident of Ohio, the accident occurred in Pennsylvania. Now, the court may obtain jurisdiction over the plaintiff when the plaintiff submits to the court's power by filing a complaint with the court. So if you are a resident of New York and you were run over by a resident of Ohio in Erie, Pennsylvania, and you sue the resident of Ohio in a Pennsylvania court, the court may obtain jurisdiction over you, the plaintiff, because you submitted to the court's power by filing a complaint with the Pennsylvania court. So two types of jurisdiction that a court must have in order to hear a case. They must have subject matter jurisdiction and jurisdiction over the parties to a lawsuit. Now, I think the jurisdiction over the parties to the lawsuit is pretty easy to understand, but the subject matter jurisdiction part needs a little bit more investigation. So let's turn to that. With subject matter jurisdiction, there are basically three types. There's exclusive federal jurisdiction, there's concurrent federal jurisdiction, and there's exclusive state jurisdiction. And what we're getting to right now is at the beginning of this lecture, I described the federal court system and the state court system. So you might be wondering, if you're a plaintiff and if you have a potential legal action that you're considering filing against a defendant, which court system are you going to file the complaint in? In other words, would the federal court have the authority to hear the case? Would the state court have the authority to hear the case? Or could you potentially file it in either court system? So let's talk about exclusive federal jurisdiction first. Exclusive federal jurisdiction is a jurisdiction that permits only the federal courts to hear a case, and federal jurisdiction is exclusive only if Congress so provides. And there are specific examples of this. The Congress has stated that if it's a case that involves bankruptcy, or antitrust or patent or trademark or copyright issues, only the federal courts can hear those types of cases. You cannot bring those cases in the state court system. So if it's exclusive federal jurisdiction, you can only bring your case in the federal court system. You cannot bring it in the state court system. How do we know if there's exclusive federal jurisdiction? Congress has said. For example, Congress has said if the case involves bankruptcy, antitrust, patent, trademark, or copyright issues, if that's at the heart of the case, those types of cases can only be brought in the federal court system. Next, concurrent federal jurisdiction. By concurrent federal jurisdiction, we mean that there's the authority of the federal or state courts to hear the same case. So if we have a situation where there is concurrent federal jurisdiction, you, the plaintiff, can choose to either file your claim in the federal court system, or you could choose to file it in the state court system. Well, when do we have concurrent federal jurisdiction? In two instances. The first is where we have a federal question over which the federal courts do not have exclusive jurisdiction. What's a federal question? It's any case arising under the Constitution, statutes, or treaties of the United States. So for example, in the U.S. Constitution, there is freedom of speech. So if your claim, as let's say a Pennsylvania resident, is against another Pennsylvania resident for violating your right of freedom of speech, which is guaranteed in the U.S. Constitution, we have a federal question. And so long as it's not that type of claim, antitrust, bankruptcy, copyright, for example, where the federal courts have exclusive jurisdiction, then you could choose to file the claim either in a state court or in a federal court. Now, the second type of concurrent federal jurisdiction is going to be a civil suit where there is diversity of citizenship and the amount of controversy exceeds $75,000. Now, in your textbook on page 48 towards the bottom, they give certain examples of what they mean by diversity of citizenship. But a simple example would be this. Let's say, for example, you are going to be suing another individual for breach of contract, and you're trying to seek monetary damages. And let's also assume you're a resident of Pennsylvania and you're suing a resident of Ohio. Because you're both from different states, you're residents of different states, the diversity of citizenship requirement is satisfied. And so long as the amount that you're suing for exceeds $75,000, then you can choose to either file the claim in a state court, or you could choose to file it in federal court. But we're going to need diversity of citizenship and amount in controversy exceeds $75,000 to get that claim into federal court. Finally, exclusive state jurisdiction. With exclusive state jurisdiction, this is a situation where you can only bring the claim in state court. You cannot bring the claim in federal court. Now, the state courts are going to have exclusive jurisdiction over all matters where the federal court does not have exclusive jurisdiction and there is no concurrent jurisdiction. So to test this a little bit, let's go to question batch 2, question 2. This provides 3 examples, and we're going to have to determine in which court or courts the claim can be brought. Now, question batch 2, question 2 states, in which of the following situations would the federal courts have jurisdiction, assuming that the federal courts do not have exclusive jurisdiction? Now, basically what this question is asking, in which of these cases do we have concurrent federal jurisdiction, right, where the claim could be brought in either a state court or the federal court? That's what it's asking. Now remember, if we're going to have concurrent federal jurisdiction, then we need either a federal question over which the courts do not have exclusive jurisdiction. So there has to be a federal question. The case has to arise under the Constitution, statutes, or treaties of the U.S. Or there needs to be a civil suit where there is diversity of citizenship and the amount in controversy exceeds $75,000. So let's take a look at the first situation in question 2. So the first situation, we have Katie, a citizen of Idaho, sues Ralph, a citizen of California. Katie's claim arises under a federal question, and the amount in controversy is $50,000. Okay, here we would have concurrent federal jurisdiction. All we have to look at is that second sentence. The second sentence says the claim arises under a federal question. That does it. That means we could get it into federal court as well as state court. So remember, if you have a federal question or there's a civil suit where there's diversity of citizenship and the amount in controversy exceeds $75,000, we have concurrent federal jurisdiction. The fact that there's a federal question here means we can get it in federal court as well as state court. So please circle Roman numeral 1. Roman numeral 2 says Bob, a citizen of New York, sues Phil, a citizen of New Jersey. Bob's claim does not arise under a federal question. The amount in controversy is $80,000. So here the claim does not arise under a federal question, but we do have a civil suit where there is diversity of citizenship, both plaintiff and defendant are from different states, and amount in controversy exceeds $75,000. Therefore, the claim can be brought either in federal or state court. We have concurrent federal jurisdiction. Please circle Roman numeral 2. Roman numeral 3, Mary Ann, a citizen of Rhode Island, sues Amy, a citizen of Rhode Island. Mary's claim does not arise under a federal question. The amount of controversy is $100,000. Now here there is no concurrent federal jurisdiction. The claim cannot be brought in federal court. It can only be brought in state court. There is no federal question, and even though the amount in controversy exceeds $75,000, there is no diversity of citizenship. So we will cross out Roman numeral 3 because the claim can only be brought in a Rhode Island state court. It cannot be brought in a federal court. Answer therefore to 2 is D, 1 and 2 only. Let's move on to stare decisis. This is going to be on page 50 in your textbook. Stare decisis is Latin for to stand by things decided. Now there are 4 rules to the doctrine of stare decisis. I'll read those to you. There's no reason to write them down at this point. As soon as I'm done reading them, we're going to take a look at question batch 2, question 3, which is going to summarize the rules. But for now, just listen to the 4 rules. The first rule is a court is generally bound by a decision in a court above it. A court is generally bound by a decision in a court above it. So for example, if you go back to page 47, figure 3.3, the state court system, if the highest court in the state court system is the state Supreme Court, then all courts below it, the intermediate appellate courts, trial courts, inferior trial courts, are going to be bound by that higher court's decision. So first rule is a court is generally bound by a decision in a court above it. If the U.S. Supreme Court lays down a rule, since the U.S. Supreme Court is the highest court in the land, all other courts in the U.S. have to follow that decision. Second rule is a court normally follows the decisions it rendered in similar cases brought before itself. So for example, if the U.S. Supreme Court has a case before it, and a year ago it had a very similar case before it, in the present case before the U.S. Supreme Court, it would normally follow the decision it rendered in that very similar case where it issued the decision a year ago. So a court normally follows the decisions it rendered in similar cases brought before itself. However, rule number 3, courts are generally not bound by their own past decisions. courts are generally not bound by their own past decisions. So even though a court normally follows the decisions it rendered in similar cases brought before itself, it is not bound by its own past decision. So every once in a while, the court will change its mind. It will not follow the decision it rendered in a similar case before it. It's rare, but it does happen. Finally, fourth rule. Decisions on courts not above a particular court may be influential on a court, but are generally not binding on the court. Again, decisions of courts not above a particular court may be influential on a court, but are generally not binding on the court. For example, if you go to page 46, those are the federal courts of appeals. So for example, if the Third Circuit Court of Appeal had a case before it, and it noticed that 6 months prior, there's a very similar case brought before the Eighth Circuit Court of Appeal, the decision rendered by the Eighth Circuit Court of Appeal may be influential on the Third Circuit Court of Appeals in deciding its case. Okay, but the Eighth Circuit Court of Appeals decision is not binding on the Third Circuit Court of Appeals decision. Because the two courts are parallel courts, one court is not above the other. So I'll repeat, decisions of courts not above a particular court may be influential on the court, but are generally not binding on the court. So if you can go down to question batch 2, question 3, this is where we'll summarize the 4 rules of stare decisis. It asks which of the following statements are true. First statement, a court is generally bound by a decision in a court above it. That is a true statement. Next, a court normally follows the decisions it rendered in similar cases brought before itself. Also a true statement. Next, courts are generally bound by their own past decisions. That's a false statement. Courts are generally not bound by their own past decisions. Finally, decisions of a court not above a particular court may be influential on a court, but are generally not binding on the court. That is a true statement. Next, let's move on to civil procedure. What we'll start in civil procedure are the pleadings. Description of pleadings start on page 53 on your textbook, and they go on to page 54. Now, what the pleadings are a series of responsive formal written statements by each side to a lawsuit. So if you're a plaintiff to a lawsuit, if you're filing the suit, the first thing that you or your attorney would prepare would be the complaint and summons. A complaint is going to consist of the initial pleadings of the plaintiff stating her case, and the summons is the notice given to the defendant to inform him of the lawsuit against him. And these are normally prepared by the plaintiff's attorney together. So for example, in the complaint, it would basically say what you're suing the defendant for. If, going back to the automobile accident, you had a defendant who ran you over and you're alleging that negligence is the action, the complaint would state that you're suing the defendant for negligence. And the complaint would also talk about the facts surrounding the incident as you see them as the plaintiff. And also in the complaint, it would state, well, how much money you're suing the defendant for. So all those things would be in the complaint. The complaint, as well as the summons, would be served on the defendant. So the defendant then is given notice that there is a lawsuit against him, and basically the facts and allegations surrounding the lawsuit. So a civil lawsuit is kicked off with the complaint and the summons being prepared, typically by the plaintiff's attorney, and those pleadings being served on the defendant. Now, after the defendant receives the complaint and summons, he will have a certain amount of time to file his answer. Now, the answer is going to be the defendant's pleading in response to the plaintiff's complaint. So this would be the defendant's side of the story. Oftentimes, the defendant in his answer will state that, in this case, maybe he was not negligent. And the defendant would also state in his answer the facts as seen through the defendant's eyes. And if the defendant is going to be suing the plaintiff for something, he would also file a counterclaim. Now, a counterclaim consists of the pleadings of the defendant describing his case against the plaintiff. Now, if the defendant is only going to be defending himself and not filing an action against the plaintiff, there would be no counterclaim attached to the answer. Now, once the plaintiff receives the defendant's answer, the plaintiff may submit a reply. This would be the plaintiff's pleading in response to the defendant's answer, and if a counterclaim is attached, the counterclaim. So this is a paperwork that goes back and forth between the plaintiff and defendant, and in most cases, the plaintiff's attorney and defendant's attorney, when a civil lawsuit is commenced. Now, after the pleadings paperwork goes back and forth between the attorney for the plaintiffs and defendant, the case enters what's referred to as the discovery phase. And this is described at the bottom of page 54 in your textbook. The discovery is a pretrial exchange of information between opposing parties to the lawsuit. So if you take a look on page 54, at the bottom of the page, after the heading discovery, second sentence after that heading, it says this procedure known as discovery includes pretrial depositions consisting of sworn testimony taken out of court of the opposing party or other witnesses, sworn answers by the opposing party to written interrogatories or questions, production of documents and physical objects in the possession of the opposing party or by a court-ordered subpoena in the possession of non-parties, court-ordered examinations by a physician of the opposing party as needed, and the omission of facts obtained by request for admissions submitted to the opposing party. So the whole idea of discovery, and this is a time between the pleadings are exchanged between the two parties and trial, is where each side tries to obtain information from the other side, so there are no quote-unquote surprises at trial. So for example, the attorney for either the plaintiff or the defendant may depose a party to try to get information. A deposition basically means that questions are asked about the party. Maybe the attorney for the defendant is going to depose the plaintiff. Maybe the attorney for the plaintiff is going to depose the defendant, ask specific questions to try to obtain answers. Maybe there's paperwork that needs to be obtained from one party sent to the other in order to answer some questions about the lawsuit. So there's this information exchange that takes place between the time the pleadings are filed and the time of the trial. And we call that the discovery phase. Now, the key thing about civil actions is that most civil actions will settle prior to trial. Only a small percentage of civil actions actually make their way to trial. So oftentimes both parties will decide on a settlement before we hit the trial phase. But if the case is still going on and the parties do not settle, then we will come into the trial phase. And the trial phase is described on page 55 on to page 56 in your textbook. Now, in the trial phase, this is where the facts, the trial is going to determine the facts and outcomes of the case. So if you take a look on page 57, this is where the conduct of trial normally takes place. So typically at trial, what we have is we have the opening statements of both parties. So basically, both the attorney for the plaintiff and the attorney for the defendant will provide their opening statements. This is where the attorney for the plaintiff will lay out his case against the defendant, and this is also where the attorney for the defendant may lay out her case in defense of her client. So we start with the opening statements. Next we come into the examinations, There could be direct examinations or cross-examinations for witnesses. A direct examination is where the attorney basically calls a witness such as his own client. So for example, if the attorney for the plaintiff called as his witness the plaintiff himself, that would be direct examination, and the attorney for the plaintiff would be asking the plaintiff questions on the stand. Now after that happens, the attorney for the defendant would have an opportunity for cross-examination. Cross-examination would be, for example, when the attorney for the defendant would then ask questions of the plaintiff. So we're going to have examinations, direct and cross. Eventually there would be closing arguments, which would sum up each party's case. And finally, there would be a verdict rendered. Verdict is described on page 57, which is going to be the formal decision by the jury on the questions submitted to it. Now, whichever party loses, they may consider appealing. And on page 58, if you take a look in the side column, an appeal is going to determine whether the trial court committed any sort of prejudicial error. And so that would be the appeal. If you take a look after the heading appeal on page 58, second sentence, says, as a general rule, only errors of law are reviewed by the appellate court. Errors of law include the judge's decisions to admit or exclude evidence, the judge's instructions to the jury, and the judge's actions in denying or granting a motion for demurrer, a summary judgment or directed verdict, or a judgment, NOV. Appellate court review errors of law de novo. Errors of fact will be reversed only if they are so clearly erroneous that they are considered to be errors of law. So basically, when the case is appealed by the losing party, the appellate court is going to determine whether the trial court committed any prejudicial error. If they find that the trial court perhaps did, then the case may be remanded, in other words, sent back to the trial court. Also, if you're a plaintiff in a civil lawsuit and you get a positive verdict that there's a sum of money that's awarded to you, you need to make sure that you're paid. So we're going to get now to the enforcement part. This is at the bottom of page 58, side column. Enforcement states, a plaintiff with an unpaid judgment may resort to a writ of execution to have the sheriff seize property of the defendant and to garnishment to collect the money owed to the defendant by a third party. If you're going to sue a defendant in a civil case, one of the things that you're going to want is you're going to want a judgment in your favor. But in addition to that, you're going to want to make sure that you're going to get paid. Otherwise, what you have is a hollow verdict. You have a verdict that's in your favor, but you're not getting paid. Now, if you're not paid in a timely manner, the question is, what can you do? Well, you can seek to have the judgment enforced. How can it be enforced? Well, again, if you take a look at the side column, if there's an unpaid judgment, the plaintiff may resort to a writ of execution and have the sheriff seize property of the defendant, so assuming some property can be found, or garnish, in other words, take a portion of their wages if they're working in order to pay that judgment. Whenever I represent a plaintiff, one of the things that I always try to make sure regarding the defendant is the defendant at least has some sort of deep pockets. In other words, that we're suing a defendant that could pay my client in the event that there is a positive award in favor of my client. Because the last thing you want is a big judgment in the favor of your client, but that's not being paid by the defendant. Finally, the textbook talks about alternative dispute resolution. This is going to be starting on page 59 in the textbook. So if you go to page 60, if you want to turn there. The textbook talks about arbitration. This is in the side column, page 60. Arbitration is the non-judicial proceeding where a neutral party selected by disputants renders a binding decision. So in arbitration, basically both parties agree that if they have any disputes, they're going to waive the right for the plaintiff to bring the case to court. Instead, they're going to have the dispute decided by a neutral third party in a more informal setting. Best example that I can give you would be I represent from time to time investors in claims against brokers or financial advisors. And if somebody opens up a brokerage account, there's almost always an arbitration clause which states that if an investor has a potential claim against a brokerage firm, then the claim will be decided by binding arbitration. In other words, the case won't go to court. And if it goes to arbitration, typically in arbitration, in a securities arbitration context, the claim is normally decided typically in a conference room of a hotel where you have the attorney and the claimant. A claimant is going to be the plaintiff in an arbitration proceeding. So you'd have the attorney for the claimant and the claimant on one side of the conference room table, and the respondent is the defendant in an arbitration hearing, and the respondent's attorney on the other side of the conference room table. And typically at the head of the conference room table would be the arbitrator or arbitrators. And what would happen is there would be opening statements just like in a trial. There will be examination of witnesses just like in a trial. And then the arbitrators would issue a binding decision. So it's going to have a similar format to a court proceeding, but it's going to be in a more informal setting. And the thing about arbitration is typically the decision rendered by the arbitrators is binding. In other words, not appealable in a court of law. Now the court mentions a couple different types of arbitration. The first is consensual arbitration. This is at the bottom of page 60. It's arbitration voluntarily entered into by the parties. So if you have two parties in a contract form that say, if we have any disputes, we both agree to decide the dispute by arbitration. Both parties have consented to arbitration. We have consensual arbitration. Page 61 in the side column also mentions compulsory arbitration. This is going to be arbitration required by statute for specific types of disputes. And the textbook gives examples of disputes involving public employees, police officers, teachers, firefighters. Some of those disputes, they're compelled to arbitration, meaning that they can't bring it into court of law even if they wanted to. Now, if you are if you file a complaint in arbitration and you are awarded the sum of money, we're going to call that an award. If you take a look in the side column, page 61, an award is going to be the decision of the arbitrator. Now on page 61 also, if you take a look at the second paragraph under the heading procedure, it says the decision of the arbitrator called an award is binding on the parties. Nevertheless, is subject to a very limited judicial process. Under the FAA, Federal Arbitration Act, and the revised UAA, these include, number one, partial or corrupt. These include, number one, the award was procured by corruption, fraud, or other undue means. Number two, the arbitrators were partial or corrupt. Number three, the arbitrators were guilty of misconduct, prejudicing the rights of a party to the arbitration proceeding. And number four, the arbitrators exceeded their powers. Historically, the courts were unfriendly to arbitration. However, they have dramatically changed their attitude and now favor arbitration. The bottom line is that the decision of the arbitrators is going to be subject to very limited judicial review. So unless you can prove some sort of bias or corruption by the arbitrator, it's not likely that a court will review the decision of the arbitrators. Other types of alternative dispute resolution can be found on page 63. In the side column, you'll see the definition for conciliation. This is a non-binding process in which a third party acts as an intermediary between the disputing parties. So in conciliation, right, you have a third party who's trying to get the two parties together to try to arrive at some sort of a settlement. There's also mediation. In mediation, this is a non-binding process in which a third party acts as an intermediary between the disputing parties and proposes solutions for them to consider. So this is one step above conciliation, because you have a third party called the mediator who tries to get the two sides together, listen to both sides of their story, and then perhaps suggest a settlement. So in conciliation, normally the mediator will not suggest a settlement. In mediation, the mediator will suggest a settlement. Now it's up to the parties whether they want to accept the advice of the mediator or not. And finally, if you go to page 64, I'll just point you to the definition of negotiation, which is consensual bargaining process in which the parties attempt to reach an agreement resolving their dispute without the involvement of third parties. So it's when both sides get together and try to hash out a settlement. I just earlier this week settled a case that was brought in arbitration. I was representing an investor. The attorney for the respondent was defending the brokerage firm. There was an arbitration clause, which meant it had to be filed in arbitration. We couldn't bring it in court. And the attorney for the respondent and myself decided that we would try negotiation. So over the phone, I stated my client's side of the story. The attorney for the respondent stated her client's side of the story. We went back and forth and finally decided on a settlement arrangement. Therefore, we did not need to go to arbitration and have our clients incur that expense. And we were able to work it out without the intervention of a mediator or any third party who would propose solutions to us. So sometimes two parties can get together, talk about the situation, and come to a certain resolution without the aid of a third party, and that would be referred to as negotiation. So let's go to question batch 2, and we have a handful of more questions to get answered. So let's go to question 4. Question 4 says that when a defendant responds to a plaintiff's complaint, the defendant files. Answer is going to be C, an answer. Question 5 says a blank is the initial pleading by the plaintiff stating his case. Answer is E, complaint. 6 says the plaintiff's pleading in response to the defendant's answer is known as. Answer is B, a reply. 7 states which of the following statements concerning arbitration is or are true. Arbitration is a non-judicial proceeding where a neutral third party selected by disputants renders a binding decision. Answer is true. Next, compulsory arbitration is arbitration voluntarily entered into by the parties. Answer is false. Consensual arbitration is arbitration voluntarily entered into by the parties. Next statement says, consensual arbitration is arbitration required by statute for specific types of disputes. That statement is false. The statement should read, compulsory arbitration is arbitration required by statute for specific types of disputes. Next statement says, the decision of the arbitrator called an award can usually be appealed in a court of law. That's false. The decision of the arbitrator called an award can usually not be appealed in a court of law. And finally, question 8 says blank is a non-binding process in which a third party acts as an intermediary between the disputing parties and proposes solutions for them to consider. The answer to 8 is C, mediation. And this concludes the lecture for Assignment 2.